Well, good evening, everyone. Tonight we're going to have facts on fracking, landowner, and mineral rights. We've got James Robertson here with Rafi. And Rafi, tell us exactly.
It's the Rural Advancement Foundation International.
Right. Thank you. And then also we've got on Skype with us is Dr. Ted Fitzsands. He's with the North Carolina College of Ag and Life Sciences. And a wealth of information between these two, and they're going to kind of help you determine your landowner rights. So, and Donna Dupree from Balsam in Jackson County really kind of urged the community to do some kind of educational facts and some information on it. So we'll keep this educational, we'll keep it light, non-contentious, and just have kind of a informative session tonight. So, good crowd. Thank you for coming. And thanks to Swain County here with the Swain County Business and Technology Development Centers. It's really a nice place to hold some things here. We've held many things here, and it's good to be here tonight. So, James, I guess I'll let it open up to you.
Great. So to start, if anybody cannot hear me at any point, just give me like a, go louder with the volume. I don't have a microphone or anything, so just feel free to say, you gotta go louder. And I'll just yell. Thanks to Rob and to Donna for having me here and for having Ted here through Skype. We're really pleased to have been invited. They did a really wonderful job organizing this. I think Ted and I would tell you that we really didn't do much at all to make this happen, and that they did all of the heavy lifting. And thanks to you all for coming out. Before I get started, I want to find out a little bit about folks in the room so I know who the audience is. Let's see. My organization works primarily with farmers around the country, focusing in the Southeast. Any farmers in the room? Great. Farmers in the room. Any folks outside of Western North Carolina? Is everybody a Western North Carolinian here? I'm a lowlander, so I just thought I'd ask. All right. Do we have any state employees or elected officials? State employees, elected officials? Would you like to introduce yourself?
Yes, I'm Vicki Green, and I'm a county commissioner from Jackson County. Layla. Everybody else who's from Jackson County.
Great. Thank you very much. It's always good to know when we have an elected official in the room, so folks know who to take their issues to. It's great. So my name is James Robinson. I work for the Rural Advancement Foundation International. We're based in Pittsboro, North Carolina, which is just south of Chapel Hill, for anybody who's not familiar with the lowland geography. We are a 501c3. We're a nonprofit organization. We've been around since the 1930s, and we were originally the National Sharecroppers Fund and the Southern Tenant Farmers Union. And those organizations grew into the Rural Advancement Fund, and our organization spun off from the Rural Advancement Fund and became RAFI in 1990. So we've been around in our current form since then. I work primarily on risk management programs, but that grows out of something else that is kind of the core of what my organization does, and that's financial counseling with farmers. We are a partner organization with Farm Aid, Willie Nelson's organization that does the concerts. One was in Raleigh last year. When a farmer calls the Farm Aid hotline and is in some form of financial trouble, is getting letters from a lender, and they're not in a good situation, they get our phone number. And if that farmer is in the Southeast, they get our phone number. And so the rest of our programming grows out of what we learn through this financial counseling. So my work on federal risk management programs, my work on leasing fairness, is an effort to make sure that fewer farmers are sitting on the other side of the table from us in some form of financial crisis. So with that introduction, I think I will get started. So this is just a little bit more about my organization. I think I've covered this slide already, but some of our focus areas are risk management, farm advocacy, that's the financial counseling. We're pretty well known in North Carolina for something called the Tobacco Communities Reinvestment Fund. The name has actually just changed for that program. It's now the Agricultural Reinvestment Fund. But that's funding that we received from the Tobacco Trust Fund Commission, and we provide, through this program, grants for innovative on-farm projects, and have been providing grants for about 17 or 18 years now. to farmers all over North Carolina. And actually, Western Ag Options has been administering those grants in Western North Carolina. And we work on contract fairness, both fracking, contract fairness, and agricultural contract fairness. And then we have a program on hunger relief that tries to help rural churches organize to address hunger and poverty issues within their community. So this is what we're going to cover this evening. This is what I'm going to cover. We're going to start out with an overview of hydraulic fracturing, because I think that's what a lot of folks are interested in hearing about. We're going to talk about leasing, split estates and forced pooling, legislative and regulatory changes impacting landowners, and then how to get involved. I'm sorry my numbering is off. It's off every time I give this presentation. I can't ever seem to get that part right. But to start off, let's talk about hydraulic fracturing. Does everybody here know what hydraulic fracturing is? It's really great to say you don't know what it is. I mean, just a few years ago I had no idea what hydraulic fracturing was. For those who don't, this is a method of extracting natural gas that is trapped in shale rock. And there is water and sand and chemical mixture that's pumped into the ground at very high pressure, vertically and then horizontally. And that mixture cracks open shale rock and releases gas that's trapped in that shale rock. And the sand that's there holds these fractures open so that the shale gas can escape back to the surface. And that's really a sort of basic description of what hydraulic fracturing is from somebody who is not an engineer. This is North Carolina's shale gas basin. This map was created by the State Geologist's Office. And in green there are the areas within the Triassic Basin that are believed to be the areas in North Carolina where hydraulic fracturing is most viable. So you have Durham counties, Granville, a little bit of Orange, Chatham County, Lee County, Moore County, some in Rockingham and Stokes, and then down toward Anson and Richmond and Montgomery counties. The area that's really been of greatest interest through this has been the Sanford Subbasin, in an area where there used to be coal mining a while back. And there was some leasing there that was done between 2006 and 2010, and we'll talk some about that. But that's where we think that hydraulic fracturing, based on what the State Geologist's Office has told us about shale gas in North Carolina, that's where we think it's most likely. So for those in Western North Carolina, depending on how you feel about hydraulic fracturing, that's either good or bad news. So let's talk about leasing and some of the history behind leasing and what some of the rights are right now for landowners who may or may not want to lease their property. That map showed between 14 and 20 counties that could be impacted by fracking in North Carolina. Gas companies, as I said, have focused on Lee County, and they've been active there since 2006. And that activity tapered off after about 2011. There were 80 leases in Lee County that were signed, and those covered 9,307 acres. And they were leases from the Whitmar Exploration Company. The Whitmar Exploration Company allowed a little over 3,600 of those leased acres to expire last summer. So we have now about 2/3 of the original leased acreage that's still under lease by the Whitmar Company. And I want to mention that if you all have questions or don't understand anything on the slides, this is a small enough group that I'm happy to take questions during the presentation and clarify anything that's on the slides. Yes, ma'am.
Well, the first presentation, you showed us how the gas was gotten down, how it was drilled. How was it captured?
That's a great question. Not being an engineer, I don't know that I can answer that very well. Donna?
Could you just repeat what she said? I couldn't hear it. If you could repeat the question.
Sure. So the question is, how is the gas captured?
You know how it's drilled for and where they get it, but how is it captured?
Right. Ted, you're here with us.
Yes.
Do you want to talk a little bit about how it's captured? I don't know that I can describe that very well.
Sure, I'm happy. Everybody hear me okay?
Yeah.
Yes.
Yep.
Okay, so you have the vertical pipe that goes down to the hydrocarbon-bearing deposit, and then you have lateral or horizontal pipes that go off in the formation, and They use small explosive charges to knock holes in those pipes, which also has the effect of fracturing the shale. Then they pour fluid out of those holes, which further fractures the shale, and also includes chemicals and sand to keep those cracks open, which takes a lot when you're a mile or more below the surface of the earth, because there's a lot of pressure. And once you've opened up the cracks, the gas then flows into the pipe, where it can be pumped to the surface. For many of these wells, once they fracture the rock and release the gas or oil, there's actually enough pressure to force it to the surface initially without pumping, but eventually it'll have to be pumped.
Okay.
Goes to the surface here. Now, with it, on this one here, when you're going so far underground, they go 2 miles. You've got 9,000 acres, but how many miles have you covered in those 9,000 acres underground?
Ted,
You don't have your underground rights.
yeah, Ted, correct me if I'm wrong, but the pipes, at this point, I have the horizontal piping I've heard running as far as 2 miles. That's something that I hear quoted every now and then.
The 2 miles has become fairly standard for the horizontal pipe. There's actually a experimental well in Louisiana where they've gone 3 miles horizontally.
Okay.
I asked him if they're piping that stuff out of people's lands that didn't lease.
Yes.
Repeat the question, please.
Are they piping gas out of people's land that did not lease? And the answer to that is yes. It's done through something called force pooling, and I'll talk a bit about that later in the presentation. Ted, do you want to mention something?
James, can I address that question?
Yes, please.
Force pooling, and the person who's pooled into the pool will get some payment for their gas.
Right.
The other question is a subterranean trespass. And the companies make an effort not to do that because you can follow the advance of the horizontal pipe in near real time from the data that the companies collect from microseismic analysis. And so if you go to a very active area like North Dakota or some of the areas of Texas, you can actually see the GPS coordinates on the map, and you can actually go back the next week and see how the drilling is advanced. And since all of the land in those areas is leased, all of the companies involved watch each other, and if somebody crosses the property line, they're going to take legal action.
So he's saying there's a GPS on the drill head?
Ted, are you saying there's a GPS on the drill head?
I don't know how the technology works, but they are able to get a GPS coordinate with a drill head in near real time, so yes.
Okay. All right. Great. Thank you for that clarification. All right. Let's keep moving. So my organization started working on fracking when we were asked to take a look at some of the leases that were being signed in Lee County, and we felt like they were predatory leasing, or predatory leases. And so the question is, what does a predatory lease look like? Well, in North Carolina, the leases that were being offered were providing somewhere between $1 and $20 in bonus payments to those landowners that were signing in North Carolina. In other areas of the country, we see bonus payments up to $20,000 an acre. Now, that is not the norm, and it would depend certainly on the amount of gas and the potential for economically viable natural gas development on your land. So sort of the, greater the chance, the more your bonus payment is going to be. But the bonus payments that were being offered in North Carolina were so low because we had very little information about what was really underground, and we had very few laws set to govern this industry. So there were just so many unknowns that landowners were really being offered leases that might not have been representative of the actual value of what was there. They were offering the minimum royalty payment, which was 12.5%. The leases generally offered unreasonably long drilling phases, so they were signing leases for 15 or 20 years, and the average drilling phase is 3 to 5 years. So you can imagine if you sign a lease for 15 or 20 years, you tie up your land and the possibility of something happening for a very long time. It makes it hard to plan what you're going to do with a piece of acreage if it could be fracked anytime in the next 20 years. And then there were a few landowner protections that limited financial risk and legal liability for landowners, and I'll talk some more about what those might have been in upcoming slides. So as a result of some of this predatory leasing, there were required oil and gas lease terms that were passed in 2012. This was a bill called 820, Senate Bill 820, that passed in 2012. And it required that companies provide educational materials from the North Carolina Department of Justice prior to executing a lease. The law required that the leases be no more than 10 years in duration, unless oil or gas is being actively produced at the end of 10 years. It set a minimum royalty payment of 12.5%. It said that landowners had to get at least 12.5% of the royalties. And it said that bonus payments had to be paid within 60 days of the lease execution. And again, this was all in response to the leasing that went on prior to 2012, and it was passed in an effort to protect landowners from what had been happening prior to 2012. There were additional...
Question?
Yes, sir.
With that royalty, you've got a lateral pipe and you've gone through 4 people's land.
Mm-hmm.
Do they have to divide the 12.5% equally amongst the...
It would be prorated based on the share you have in the drilling unit, which would generally be based on the amount of acreage, I think, that you have in the drilling unit. So if a standard drilling unit is about 640 acres and you own 1 acre, within that you would have 1 640th right to the royalties coming out of the entire drilling unit. Ted, does that sound about right?
Yeah, that's how it's divided up.
Okay. So the additional required lease provisions said that compensation for any water use on the property had to be provided. That leases must provide that an operator will pay reasonable costs for water testing within 1/2 mile radius of the wellhead. That notice of assignment is required. This means that if a company leases your land and then sells that lease to another company, they have to provide you notice of that, and this is a very common practice. It required a provision in there that recommended you seek approval from your lender. Signing one of these leases could, in theory, put you in violation of your mortgage or any other agreement you have with a lender related to your property. And it again recommended that you get a sign-off from that lender saying, signing this lease doesn't put you in violation of that. And then it gave a 7-day right of rescission, meaning that you could cancel the lease within 7 business days. And that's, so if you decide that the company you signed with is a bad actor, or if someone in your family signed a lease who maybe shouldn't have been forced into making that decision or coerced into making that decision, you can cancel that lease.
So James, these
Yes.
these laws you're talking about are they the regulations that the Mining and Energy Commission has come up with?
Well, that's a great question. These are not. So these are in statute, and these were passed by the General Assembly
They
in
actually
2012.
were. Okay.
Yes, so these are in statute.
Okay.
Who decides what is reasonable?
It's a great question. It is undefined what is reasonable. There would be a hearing in front of the Mining and Energy Commission about that. Ted, does that sound right?
Yeah, the Mining and Energy Commission will decide what's reasonable.
Wait a minute.
Yes, sir.
Why aren't we using the today standard?
The Today Standard?
Yeah.
I'm actually not familiar with that. What is that?
The Oil and Gas Commission, the ones they came up with now, that's been voted on in Raleigh.
Oh, so the one
today.
Yeah. So the Mining and Energy Commission rules actually go into effect on March 17th, so tomorrow, and we're going to talk some about what those are. So there are two sort of levels of of governance that you can think about in this case. So one is statutory, which the General Assembly passes, and the other is regulatory that the Mining and Energy Commission works on. And so what this is covering are statutory requirements, and then there's a second set of in most cases, much more detailed rules that the Mining and Energy Commission puts together that deal with things like permitting and drilling unit applications and land reclamation, and we'll talk some about what those are as well. Does that answer your question? Okay,
Yeah.
great. Okay, so mineral leasing since 2012. I sort of talk about mineral rights leasing as happening before 2012 or after 2012, because the whole game sort of changed in 2012 when Senate Bill 820 was passed. But since 2012, we've had one company, at least, offer leases in Durham and Orange counties. In 2014, the company's name is Crimson Holdings. They're out of Pittsburgh, Pennsylvania. The leases that were being offered were in violation of almost every statutorily required term that I just showed you on the previous two slides. I believe that the only one they were in compliance with was the 12.5% minimum royalty payment. They may have been in compliance with one or two others, but just about every single one they were in violation of. So the North Carolina Attorney General sent Crimson Holdings a cease and desist order and asked them to not do business in North Carolina because they weren't in compliance with North Carolina law. And so I say this really to illustrate the point that there are bad actors out there, and they will try and take advantage of landowners, even now that we have these protections in place. So it's important to know what these protections are so that when you have interactions with some of these oil and gas companies, you can say, that's not right, I know my rights, and I'm protected under the law. So leasing tips for landowners. So this is time for you to look at the first handout that I provided, and it's a handout from the North Carolina Department of Justice. And I won't read through the whole thing. I would recommend that you read through that document. But this is really for anybody who is considering signing the mineral rights lease. And these are some of the most important points that you will find in that document. And again, my numbering is off. Actually, someone in the last presentation said that they were all number one because they were all most important. So I like that. We'll go with that. So first, talk to an attorney. We really can't emphasize this enough. I should tell you that I am not an attorney. You should not take legal advice from me, but you should take legal advice from a North Carolina attorney that is registered with the bar. You should contact your mortgage lender, your conservation easement holder, farm service agency office, whoever you may have a relationship with related to your property. You should talk to them about signing one of these leases. You should check out the Landman registry to verify registration. Landman is the industry term for someone who is out trying to get landowners to sign oil and gas leases. And there is a registry of landowners on the North Carolina Department of Environment and Natural Resources website. And that is there so that you can verify someone's identity. If someone comes to you and says, I'd like you to sign this lease, you can go to that website and see if they are who they say they are. So it's fraud protection, and it allows you to check up on what kind of record they may have in the past. Yes, we have a question.
What are the requirements for someone to be signed onto that registry?
That's a great question. The registry is probably not as effective as it could be. It probably needs some teeth. Right now, it just requires someone to essentially put their name and their contact information and whether or not they are a registered landman in another state. But other than that, we don't know very much about the people who register for this website. And last I looked, there were, I believe we were approaching 50 people who were registered in North Carolina. So that's the state of that right now. Ted, do you want to answer that question as well?
Could you repeat it, please?
Sure. The question was, what are the requirements for being registered on the Landman registry with Diener?
I would have to look at it again because I haven't looked at it recently. While you speak, I'll take a look and see if I can come up with an answer. Okay?
Okay, great. Thanks, Ted. And then the last point on there is to research the oil and gas company, see what they've been doing in other states. You can find out, whether or not they have a good environmental record and whether or not landowners have been, complaining about their business dealings with a company. So research them and make sure they're going to be a good corporate actor.
Website.
James,
Yes.
what is a conservation easement?
Conservation easement is a legal agreement that allows you to lay out what is going to happen on your property over sort of an extended period of time. It essentially allows you to say this has to be kept as farmland, or it can't be developed in a certain way. It's an agreement that a lot of folks go into with like a land trust. Ted, since that is a legal agreement, do you want to describe what conservation easement is in legal terms?
Sure. A conservation easement is an agreement that complies with state law, and if it is a perpetual easement, it meets the requirement for a charitable deduction under the Internal Revenue Code if it is if it's a donated easement or if it's donated for less than fair market value. And there's several requirements. One, you have to have a conservation agreement. There has to be something of conservation value on the property. That can be historic structure, that can be unique habitat for plants or animals, and it also includes agriculture and forestry. All of those qualify under the law. That's just a brief description.
But how would you set something like that up? Would you call with your attorney, or with, do you do it through a deed? I mean,
You can talk to an attorney, or I might recommend contacting a land trust. There are a lot of land trusts that work on those agreements. But Ted, do you want to? How would you go about setting up something like that?
Well, the first thing you have to have is you have to have either a land trust, which are organized as private 501c3s, those are charitable organizations, or you have to have a governmental entity, typically a soil and water conservation district, that's willing to hold the easement. Because if you don't have an entity willing to hold the easement and to monitor compliance with the easement, you can't have one.
Great explanation. And you asked about a website.
Yes, do you have any flood protection websites or any of those websites?
Well, two things I would say. One, if anybody approaches you, I would check to see if they're registered on the Landman Registry, which is on DENR's website. So that's the Department of Environment and Natural
It's
Resources.
listed on the sheet. I don't get catch
And then the other thing that I would say is that if anybody approaches you, I would ask them who they work for, and then I would research that company specifically online, and go to their website, and then go to any other website that you can find that's writing about it. See if there are news articles about the company. If there have been spills or things related to that company, there was probably a news article about it in another state. So that's the sort of thing that I would start doing.
And what type of agreement with, go back to that.
Go back. Okay.
What type of agreement with the Farm Service Agency would you have that would affect?
Well, you can have a farm ownership loan. Your actual loan that you're paying for ownership of that farm may be through the Farm Service Agency. They provide a number of financial services for farmers.
But does it also have to do with, I know when tobacco went out, there were some, I guess, special allocations or something given to farmers to replace what they were making with.
Right.
Would that affect it?
Payments, the tobacco payments that were made with the end of the tobacco quota program, those tobacco payments actually ended last year. So this is the first year since the end of the tobacco quota program that we're not going to have payments to farmers.
So that wouldn't affect it anymore?
I don't think so.
Okay.
No, I don't think so.
James, if I can jump in,
Please,
I've
please
pulled the Landman Registry application.
Okay, yeah, please.
It's a pretty simple application. It's on the DENR website. If anyone wants to look at it, just search on Landman. And it asks for the person's name, their business address, phone number, email address. They're then asked if they are registered as a landman in another state. They're asked to list all the jurisdictions where they're registered. They're then asked if the registration or license has ever been revoked or suspended. If the answer to that is yes, they're asked to describe that. They're then asked whether or not there are any pending judgments or tax liens against them. They sign it. Individuals provide their social security number, and for those employed by a business, they provide their federal EIN number, which is the tax number for the IRS. And they're required to notify the state of any changes within 30 days.
Thank you, Ted. That was really helpful.
You're quite welcome.
Okay, the next section is going to be about split estates and forced pooling. These are a couple of the issues that my organization has spent some time working on, and they are a couple of the unresolved issues that surround fracking right now. So first, split estates. This very simple picture shows you two different scenarios. Landowner A is on what is called a unified estate. So the landowner owns both the surface of their property and the subsurface of their property. Landowner B, however, only owns the surface of their property, while another individual, I guess you could probably call them landowner C, owns the subsurface of the property. And so the split estate is the estate there on the right. It's not unified, and you have two different owners on what would, normally be looked at as one piece of property. So there are some problems with this. There's some problems that are presented with split estates. I give you some data here from Lee County because Lee County has done some really nice work collecting data from the Register of Deeds and putting it into their GIS system and doing an analysis of how many parcels in their county are split estates. And they've done this because, as I said when we had the map up, it's really sort of been the area of focus for this issue in North Carolina. But in Lee County, there are 365 parcels about the size of 12 square miles that are split estates. It's a problem because we have limited information about how mineral, oil, and gas development will impact property value. So if you're on a split estate and you don't control whether or not oil and gas development happens on your property, essentially it means that it may be harder to get a loan for that piece of property. In fact, I talked to somebody on the phone just last week who was trying to buy a piece of property, and it was a split estate. It was a known split estate, and the owner of the subsurface didn't even know that they owned the subsurface. It had been inherited through their family, and they had been unaware that they had inherited it. And the person who was trying to buy the surface couldn't get title insurance because it had been split. So it caused us some problems. The State Employees Credit Union actually has stated that they're not going to offer financing on split estates and property with mineral rights leases. I always like to say that's not the State Employees Credit Union making a statement about whether or not hydraulic fracturing is good or bad. It's just a statement about the risk involved in investing in something that you don't know much about. And they're essentially saying we don't know enough about this industry and what happens on a split estate or with mineral rights development to know whether or not we can responsibly lend to someone buying a piece of property like that. So this is time to look at your second handout. We have lots of questions about mineral rights title searches when we start talking about split estates. And the second handout, I believe, is called something like conducting a mineral rights title search. And it tells you what's involved in conducting a mineral rights title search. And the first point up here is, again, to talk to an attorney. Mineral rights title searches can be very complicated, and Ted will describe in really great detail why they are so complicated. But they can be very complicated. They can involve a lot of legal language. So it's great to talk with an attorney about any efforts to create a deed chain and determine mineral rights ownership. You would do that through the Register of Deeds. Ask about mineral rights versus oil and gas rights. Those are not the same thing, and Ted will also go into great detail about the difference there. And then check with the Register of Deeds. It's a great thing to just start with a call to your Register of Deeds. That's where all of this ends up. So if your estate has been split, it should be reported at the Register of Deeds. If there is an oil and gas lease for the mineral estate under your property, that has to be recorded at the Register of Deeds within 30 days of the signing. So you can contact the Register of Deeds and find out a lot of information. But to reiterate, determining for sure what some of these documents mean may require an attorney. Yes, ma'am.
We're talking a lot about attorneys. Are there any attorneys that work pro bono on any of these matters?
Yes. What we would say is to call the North Carolina Bar Association, and they do have a way to get you in touch with attorneys that would work pro bono on that. We don't recommend individual firms just because we, as an organization, don't like to pick certain private entities over others. But I would recommend getting in touch with the North Carolina Bar Association. Ted, do you want to say anything about that, about choosing an attorney?
Yeah, the lawyer referral service is on their website, and those are attorneys that have indicated they do that type of work. Unfortunately, we have very few attorneys in North Carolina that do mineral rights title searches. In lieu of that, you would need to get an attorney at the very least who does commercial real estate transactions.
Is there anybody nationwide, like AARP or something, that would provide attorney information just to get an idea?
Is there anyone nationally, Ted, that you know of, or an organization nationally that may be able to recommend?
No, since attorneys are licensed state by state, you really need to go through the state bar associations. In North Carolina, it would be the North Carolina Bar Association's lawyer referral service.
Great. I think I saw a hand in the back. No? No? Okay. All right. Well, let's move on. So force pooling was the second issue that I said we would talk about. Does anybody know what force pooling is? Has anybody heard of this? All right. We have some hands go up. This is a very contentious issue. In the effort, to have full disclosure, I'll let you know that my organization has worked to oppose force pooling. I won't necessarily talk about that here since this is just an informational meeting, but if anybody would like to meet with me afterwards in a different setting, I'd be happy to talk about why we oppose force pooling. But this is known as compulsory pooling in North Carolina. It's used to create a drilling unit. Drilling unit is the area that a gas company believes they can withdraw natural gas from one well or from one well pad. Those are generally about 640 acres, so about 1 square mile. But it's used to create a drilling unit by forcing non-consenting landowners into participating in a proposed drilling unit. So this was getting at the question around whether or not there are folks that are having their gas extracted who didn't sign a lease. Force pooling is used to do that. This is currently legal in North Carolina. It has been legal since 1945, and I should say that it's legal in roughly 40 other states. So it is not uncommon, but is still a very contentious issue. What's important to understand about North Carolina's law is that nothing in the law indicates when and how force pooling can be used. So we don't know how many landowners have to be leased in a drilling unit before you can force the rest of them. We don't know how much of the acreage has to be leased before you can force the rest of the acreage. It doesn't say who decides, although it would sort of be implied that the Mining and Energy Commission or the Oil and Gas Commission, when that is formed, would decide. We don't have any information about what the appeals process would be for somebody who gets force pulled in and says, I don't want to. We just don't have any information about how it can be used. And so there's been a lot of conversation in Raleigh about whether or not the state actually, under this statute, has the authority to do anything. Since it doesn't give the specifics that we need to know about how this can be used.
That's versus states' rights. Property rights.
Yes, it is. You're exactly right. It's a property rights question. Yeah. So how much does a landowner have the right to say no?
How is the state government handling that?
How is the state government handling that?
Are they planning to change?
Oh, it's a great question. So in 2012, the legislation that passed, 820, it had a provision within it that required the Mining and Energy Commission to study compulsory pooling. It didn't change the law, but it said the Mining and Energy Commission has to study it, and they wanted a study of it because they knew the law as it was written was inadequate. And my organization and TED actually participated in that study. We were non-voting members on that study, but we were there as sort of folks to inform the Mining and Energy Commission members. And that study was completed in October of 2013, and it was provided to the Department of Environment and Natural Resources, and they technically did not deliver it to the legislature. So we didn't really have those recommendations go anywhere. The recommendations can be found on the Mining and Energy Commission website. Among other things, it recommended a 90% threshold, leasing threshold, before any forced pooling could happen. What that means is that 90% of the landowners would have to agree, voluntarily sign a lease before the other, or excuse me, 90% of the acreage. This is a really important distinction actually, and I don't need to mess this up. So 90% of the acreage would have to be leased before the other 10% of the acreage could be forced in. One of the problems created by that is that 90% of the acreage might be owned by a handful of landowners, while the 10% of the acreage is owned by several hundred landowners in a subdivision. So this recommendation creates a scenario in which a very small handful of landowners could force in a very large number of landowners. And you can obviously see why this would be contentious. It feels sort of undemocratic. It feels like it's taking property rights away. And I think folks in Raleigh have probably been a little slower to move on this just because they understand that it is a very sensitive issue, and that protecting the property rights of landowners is a very important thing to do. So they have sort of taken this at least first step to study it, and we don't have anything else yet. Actually, well, there is a second study. They've asked for a second study, so we'll see how that goes. So this is another very simple depiction of forced pooling. This is what, when that law was originally written in 1945, this is what they were talking about when they said forced pooling. This is a reservoir of free-moving oil. If landowner A puts a well in the ground and starts to draw out their oil, they're going to draw landowner A's, their own oil. Landowner A is going to draw their own, and they're going to draw landowner B's, whether they mean to or not. And so forced pooling was there so that landowner B got some compensation for the resource that they lost. And it was really fairly protective. It was a good thing if you were landowner B. It meant that you didn't have to put your own well in the ground and race to drain the oil from your property. And it was actually, you could argue that it created some environmental protections because you could put fewer wells on the ground.
Before you leave, go ahead.
It's okay, I can stop if you have a question.
What if I get ticked off at landowner A and I got friends in low places? What if I drill my own, suck his oil out?
Well, there is a legal concept called the rule of capture. And the rule of capture says that whatever comes out of the well on your property is yours. And so essentially what forced pooling was there to do was to make that a little more fair. So that it was yours, but you had to provide compensation to landowner B. Before we had, forced pooling agreements, that's exactly what would happen. You would put a well on your property, your neighbor would put a well on their property, and you would race to drain it. And whatever you got out of the ground on your property, whether it came from under your property or under their property, was yours to keep. So compulsory pooling in unconventional natural gas situations. This is what we're talking about in North Carolina when we talk about forced pooling. We're not actually sticking a well into the ground and drawing what's underneath ours and sort of, because of the physics of it, drawing what's underneath the neighbor's property. We're actually going after what's underneath the neighbor's property and many other neighbors. And it's it's important to understand the difference. We're not migrating oil, free-moving oil toward a well when we're actually going after trapped natural gas. And so the question then becomes, how much does landowner A have the right to essentially go get the gas under landowner B and C and D, their properties, in order to essentially fund the well that's on their property? When they don't have to do that, the gas wouldn't come to them anyway. They're going to get it to essentially make the well cheaper that's on their property. Yes, sir?
Except in this instance here, we're talking about poisoning the earth underneath landowner B's property, as well as all along the pipe.
Yeah, that's certainly a point worth raising, and an important thing to think about what the impacts may be for the other landowner.
Well, good frack.
Right. So let's talk about some of the legislative and regulatory changes impacting landowners. We talked a little bit about it with the leasing, but that just pertains strictly to leasing. Let's talk a little more broadly about it. We're going to get a little bit deep into some of the stuff, so get ready, like pinch yourself if you're falling asleep a little bit, because this is going to get sort of deep into some of the stuff. I mentioned Senate Bill 820. It's known as Session Law 2012-143. It passed in 2012. It legalized the processes involved in hydraulic fracturing, but prohibited permits until regulations were finalized. Those regulations have been finalized and they go into effect tomorrow. So we are now there. You will be able to get a permit to do this in North Carolina. And this legislation also tasked the Mining and Energy Commission, or the MEC, with creating the regulatory structure to govern natural gas development, as well as other types of mineral gas and oil development. So this gets at your question about the difference between statutes that are passed by the legislature and then rules that are written at the administrative level that provide greater detail around what's going on.
But the General Assembly had to okay these regulations.
You're correct. The original legislation required that the General Assembly approve those rules after they were completed. And there was a bill that passed last year, Senate Bill 786, that pre-approved those rules and said, whatever you give us, we'll be good with it.
786.
And I'll talk some about that. Yes, sir.
The North Carolina Court of Appeals just ruled that the Mining Commission is unconstitutional. I mean, just a few minutes ago.
Just a few minutes.
Really?
Did they really?
That's a really important problem. So those rules may not go into effect tomorrow.
Right. They may not. Well, that was my question.
Yeah.
What kind of comments do you have on that? Because I know you probably anticipated the possibility of that.
Didn't they rule it?
Court of Appeals.
Yeah, Ted, I might ask you to jump in on here on this since you are an attorney. So apparently the Court of Appeals has ruled the Mining and Energy Commission unconstitutional. So what does that do to the rules going into effect tomorrow?
It very much puts them in doubt.
Very much puts them in doubt.
And big stoolies.
Reading the Court of Appeals opinion, it's not real safe to say too much, but I don't see how a commission that is not legally constituted can produce regulations that are legal.
All right. Well, with that, let's all go home. No.
James, I'm going to see if I can find that opinion on their website.
Yeah, Ted, that'd be great. This is really real-time stuff happening. This is great. It's very exciting.
Is that subject to appeal to the Supreme Court?
And he is a lawyer.
Well, because it's unanimous, no, but because it involves a constitutional question, yes.
Yes.
So I have no doubt that it would be probably appealed.
Yeah, but they couldn't issue any permits.
Not in the meantime.
No.
Where did you see that? Where, is that
Some
really?
News and
Did you read it?
Observer and WRAL, and it's
Kind of official.
it's the main news on all the websites.
Whether or not it's whether or not there's a stay is anybody's guess. I don't know. If there was a stay issued, that means that ruling would be good until it's overturned by the Supreme Court.
Or not.
Or not, yeah. I haven't read it. I mean, we just got news on this stuff, so I don't know whether it stays issued or not.
All right. Well, we'll keep going, and we'll talk about some of those rules that may or may not now be in effect.
Well, the reason I asked the question was because I was trying to figure out, you've got the session laws, and then you've got these regulations. Once the General Assembly okays the regulations, does that give them more weight like a session law?
They do have legal power, as I understand it, Ted. I mean, you have to follow these regulations, as law. I mean, before the General Assembly approved them, they had not gone into effect. They were just proposed rules, and then when the General Assembly approves them, they are then regulations in effect. They are the law.
Okay.
That has to be followed. That's my understanding of it.
Okay.
But then the governor questioned the legality of the Mining and Energy Commission.
Yes, ma'am.
Because it had so many members that were appointed by the legislature. And the Court of Appeals ruled in favor of the governor, I guess, in this instance.
It was actually the governor, the former governor Jim Hunt,
Yeah.
and former governor Jim Martin.
Yeah.
They
Right.
were all plaintiffs in that.
Right, and the general complaint was that the legislature had given themselves more appointments to state commissions than were constitutionally available to them, and that was the job of the governor and the executive branch. So that was the argument that apparently has, at least in its first step, been successfully argued. So landowner protections. This is 820 that passed in 2012. So water usage. It said that leases must have, or must state, I mentioned this earlier, if water is to be used. It's talked about operator baseline water testing, and this is an important one to look at because it's going to change in the next slide when we talk about the next piece of legislation. Operator water testing. It said that operators must conduct baseline water testing of all wells within 5,000 feet of a wellhead. That was in 820, and that changed. So we'll see that on the next slide. There was presumed operator liability. It said the gas operator would be presumed responsible, for contamination of all water supplies within 5,000 feet of a wellhead. And then replacement water. It said the operator must provide a replacement water supply that is, quote, this is the language from the statute, that is adequate in quality and quantity for those persons' use.
I have a question.
Yes.
Does that mean personal use? What about the cattle? What about your, if you're irrigating?
I believe that it would have to replace the water for any purpose, for which you were using it. I believe, but I hesitate some to say that because I'd have to go back and look at the legislation.
Because the way that's written right there, that's just drinking water. The cows,
Right.
You either sell them or haul water from somewhere else for them yourself.
Yes, sir. You're exactly right. I'll make note of it and I'll check and make sure that I can get an answer for you. Yes, sir.
This is poison water we're talking about?
We're talking about any water. So if you conducted baseline water testing and said this is the chemical makeup of my water supply, and you conducted testing after drilling took place, and that chemical makeup changed in a significant way, so that there were chemicals included in your water supply that had also been a part of the hydraulic fracturing process if you were within 5,000 feet of a wellhead, that meant that it would be presumed that the company contaminated those water supplies. It's a rebuttable presumption, so the company can present evidence to suggest that they didn't do it. But it would be presumed that they did it, and then they would have to replace the water supply. Yes, sir.
Has any court in any other state issued such a claim that the...
I don't know the answer to that. Ted, do you know if there's any other state where we've seen this presumed operator liability issue litigated
confirmed
before it was confirmed?
Can you state the question again?
Sure. We're talking about the presumed operator liability for any water contamination, and there's a question about whether or not there have been cases in other states where the presumed operator of liability was
The court
challenged.
found for the defendants, the ones with the poison water.
Where the court found for the defendant with the poisoned water.
I don't know of one.
The short answer is yes. The longer answer is that they are very difficult cases to win, so most of them end up settling.
Yes, sir.
If the issue is poison water and it wasn't poison before they got there and it's poison after they get there, what's the issue?
Let me go into that.
Sure, Ted.
You have to have a test of your water for the substances that poison your water before the drilling began. Since the fluids used in drilling are held as trade secrets, it's not always possible to know in advance what you need to test for. That's one of the problems. Second, the lab has to be one that can provide the chain of custody from the sample being taken from your well to their laboratory, and have analysts or scientists who can testify as to what they found. So if you don't test for the right things and you don't have the chain of custody so that the test can be admitted into evidence, it becomes a very difficult case to win.
And was the legitimate.
Why? Why is it difficult? It was poisoned after they got there.
With what?
Yeah, unfortunately, I don't think that's a question that I can answer. I mean, it would be a question for the court that decided that, you know, that
Probably right,
individual
Sinead,
case.
right?
Yeah.
If I decide my water's good today, but 10 years from now it's not good after they drill today's analysis stinks.
It's a good question. So that it probably would not. I'll let Ted answer that. It probably would not. The legislation actually does lay out how many recommended testings there are after drilling takes place, and it doesn't go out 10 years. So if you did testing 10 years after, that would begin to fall outside of what the legislation
10 years
says.
before.
Right.
Like
Or
my
10
well's
years.
good now.
Yeah.
If they come in 10 years from now and drill and it's not good anymore, is that test that I took?
No, it wouldn't. I mean, the legislation says testing should take place X number of days before.
You have to have it tested pretty any of the time.
Right. The testing would have to follow, I think, the recommendations as close as possible as they are laid out in the legislation, which says you should test this many days before and this many days after. Yes, sir.
In North Carolina, the health department requires anyone who has a well dug anymore, water well, has to be tested. So anyone who's had a well drilled within the last, I don't know how many years, there should be a test somewhere of what's in your water.
Right.
And it should be your baseline.
Yeah, Ted, please. Yeah, Ted's good. He's got answering that as well.
A lot of the tests that you get through your county health department, well, they're good enough to tell you that you may have a problem that you need to do something about. They don't have the chain of custody necessary to create evidence that can be introduced into a lawsuit. Because you have to show, you have to document that the sample was taken from your well, and that was in fact the sample that the lab actually tested. And for a lot of the tests done by county health departments, they don't do that. So the attorney for the gas company that was accused of contaminating your well can keep that evidence from being introduced in a lawsuit.
Okay.
If I could just bring up one
Oh,
thing.
and James, I pulled up this decision if this is a good time.
Yeah, it is. It is. Please go ahead.
So,
Okay, so the decision is actually, let's see, it's actually a Superior Court decision, not a North Carolina Court of Appeals decision. And because the issue is a constitutional issue, I believe it was the Supreme Court formed a 3-judge panel, so this is a little unusual Superior Court. It's a 3-judge panel that's been pulled together to hear the constitutional issues. And now it's my understanding that it will actually skip the Court of Appeals and go directly to the North Carolina Supreme Court. But the gist of what they decided is what you said, James. The appointment to these commissions was a majority by the legislature, and the unanimous panel found that that is an unconstitutional violation of separation of powers. So at this point, it will be appealed directly to the North Carolina Supreme Court.
Okay, thanks,
Okay.
Ted.
So,
You're welcome.
Oh, yes, Don, please.
since we're talking tonight a lot about leases,
Yes.
the first one, the property, the use of, well, now you've changed it.
I can-
The
I can
use,
go
getting the use of water from, on the property.
Right.
Can't you, in your lease, say that that they can't use your water?
Yes. Yeah.
I mean, that would be important in any kind of, not just oil and gas, but in any kind of contract.
Yes, and that's a great point to make about anything. There is nothing that is non-negotiable. When you get handed a lease from one of these oil and gas companies, they will act like, that's the lease. This is what you get. Everything in that and more is negotiable. If they want your natural gas, then they've got to come to the table with you, and they have to talk to you about what you want for your property. So that's a great point.
But it could be a mining company.
Yes.
It could be a sand and gravel
Exactly.
company, whatever.
Exactly. Yes, ma'am.
Well, you said in the poisoning water, do they present what kind of chemical they use for fracking?
It's
protected by law.
See,
that's where they're wrong.
Yeah, well, they do have to disclose chemicals unless they fall under North Carolina's trade secret law and are protected under trade secret law. So this is the same thing that makes us unable to know the complete formula for Coca-Cola. And I talked some about that set of the regulations. Those are part of the Mining and Energy Commission's regulations. And so I'll talk a little bit more about that. Okay, so some of the additional protections that were in 820, it required 30-day notice for any land disturbing activities. So before they come on your property, they have to give you 30-day notice. It said that the operator is liable for damage, and the operator, resulting from any of the operator's activities. Surface reclamation, it talked about the operator being responsible for reclamation of the surface within 2 years of completion. There's a reclamation bond required. That is going to be, that bond value is going to be set by the Oil and Gas Commission. The land and registry, I mentioned that. It was required in that legislation, and then the 7-day right of decision, I've also mentioned that as well. Okay, so these were some of the changes that were made. I mentioned 786, the legislation that pre-approved the rules. That's Session Law 2014-4, same thing. So it pre-approves the MEC regulations, lists them this spring. Now we know that they may not go into effect tomorrow because of this decision. We're unclear at this point. Chemical disclosure. So here's your question about chemical disclosure. It says that chemicals must be disclosed unless protected by trade secret law. The trade secret protected chemicals will be held with the North Carolina State Geologist's Office. The presumed liability for water contamination, I mentioned that this is an important one to remember. That's because this piece of legislation reduces the presumed liability for water contamination from 5,000 feet to a half-mile radius from the wellhead. So it actually reduces the land area that the company would be presumed liable for by 70%, because we're talking about a radius. As I mentioned earlier, this is a rebuttable presumption, meaning that the operator can challenge their liability, and the landowner must be able to show a pre-test of water resources that establishes that chain of custody that Ted was talking about. And then well water testing. This was one of the really unfavorable pieces of this legislation for landowners. It actually places the burden for well testing on the landowner rather than the company. It does say that the company will pay a quote-unquote reasonable amount But it does reduce the effectiveness of this presumed liability because the landowner themselves actually have to conduct the testing now, whereas the original legislation required that the companies conduct the water testing. So now it is that much more important for landowners to understand what their responsibilities are. So even if you don't lease, but you're within a half a mile of a wellhead, it's going to be really important for you to know that you're responsible for testing your water, but that the company is supposed to pay for it, according to North Carolina law.
Where's the 5,000 feet?
The 5,000 feet was in the original legislation.
Yeah, but
And-
when at 2.5 a mile, now half a mile is less than 5,000 feet.
You're exactly right. You're exactly right. That's what
I
happened.
understand where they're coming from too. They're reducing it.
Yes, that's exactly what happened. Yep, you got it. They reduced it. Yes, yes, sir.
Is there any type of testing that would be a standard for a courtroom? It could be official?
Yeah, Ted, you want to describe this again? Is there any type of water testing that would be official for a courtroom? I mean, what I would say, I guess, is it's something that establishes the chain of custody and goes through an approved North Carolina lab. There is a list of North Carolina approved laboratories. Certified, yes, sir. Yeah, Ted, do you want to add to that?
The answer is absolutely. If you go through of course, you're better with a North Carolina certified lab, but it doesn't have to be as long as it's a lab that meets national standards and you have the chain of custody. I'll also add, James, that I just sent you and Robert a copy of that opinion.
Okay, great. Thank you, Ted. Okay. Session law 2014-4 continued. It created the North Carolina Oil and Gas Commission and Mining Commission. So later on this summer, the Mining and Energy Commission will actually cease to exist, and we will have a new Oil and Gas Commission and Mining Commission. There was a preemption of local ordinances. So that legislation repealed any local ordinances that prohibited the siting of wells or oil and gas exploration, development, and production within any county, city, or other political subdivision, prohibit fracking, place any restrictive or condition on oil and gas exploration or conflict with that particular piece of legislation. So it did a lot to make sure that local governments couldn't determine for themselves what they wanted to do with fracking. And what the politicians who made those decisions would tell you is that they were trying to create uniform rules across the state. Of course, you know, local governments, I think, would disagree with the need for that and want some control over it. Yes, ma'am.
Now, this is a little bit maybe off topic, but for those of us who live in Swain County, there's a huge amount of federal land all around us and some state land as well down along the Little Tennessee. I want to know what if there's a unit that requires, you know, going into state or federal lands or the national park, for instance, what will happen? Do we have any idea?
We do. Ted, you would probably be better at answering this than I would. Do we have an idea about what would happen if, say, a drilling unit wanted to include federal lands or a state park?
Federal lands are governed under federal law, and there would have to be a provision of federal law to allow drilling, and where drilling is allowed on federal land, there is a process to lease it, and as far as I know, that process does not exist on any federal lands in North Carolina because there isn't an established market. So that would be very difficult, if not impossible, to drill on federal land in North Carolina for the foreseeable future. For state parks,
How about state game
I am
lands?
not aware of any provision of state law that addresses that, so I don't really know the answer. I don't know if you've seen anything, James.
I have not. Early in the Mining and Energy Commission process, there was a presentation on how this may play out on state lands, and the presentation was exploratory, so I don't think we came to any conclusions based on that. So I think you're right. I don't know that we know how we would deal with that. but we need to look into it further to fully answer that question. Notice of initiation of exploration. So if you remember, there was the notice required before any land disturbing activities. There's also a 30-day notice required before any initial exploration. So this is any activity that's not land disturbing, going in and surveying, things like that. And then additional study of forced pooling. I mentioned this earlier. This is the second study that Diener is conducting that was required by Senate Bill 786.
James,
Yes.
you talked about the notice required. Is it notice only to the person who has leased the land, or is it notice to the public and all the neighbors?
It would be notice to the landowner.
Just to the landowner, so somebody
yes.
next door might not hear about it.
Yes, that's correct. So the Mining and Energy Commission rules. So what we've been talking about are statutes that have been passed by the North Carolina General Assembly. So now we're going to talk about what the Mining and Energy Commission did. And they were given authority to do this by the General Assembly. And these are the rules that may or may not go into effect tomorrow, depending on the impact of this court decision. There were 120 rules that were developed to govern the fracking process. They covered everything from permitting to land reclamation. The entire set of rules can be found at that tiny URL if you would like to write it down. We created a short link for you there through which you can find the entire rule set. And then there was a public comment period held between July 15th and September 30th. There were 4 public comment periods. One of them was held in Cullowhee. So there was a public comment session provided in Western North Carolina. Oh, I'm sorry. Yeah, please go ahead. Let me know when everybody's good. Sure. Everybody got it?
Yeah.
Okay. So some of the key MEC rules that landowners should know. As I said, there are 120 rules. I mean, if you're having a really hard time sleeping at night, it would be a good thing to pull out and read. So this is just a very, very brief look at some of the important things for you to know, but certainly not a comprehensive list. The first thing that I would point out that would be important for landowners to know are setback distances. So setbacks are the distance that a well, it's measured from the wellhead, has to be from, or any other, I think, infrastructure, well infrastructure on the well pad. This is the distance that has to be from, say, a private home, or a school, or a hospital, or a nursing home. And a private home would be an occupied dwelling. That setback distance is required to be 650 feet. From a public road, the distance is 100 feet. From a stream, river, watercourse, pond, lake, wetland, or other body of water, it's 200 feet. An intermittent stream is 100 feet, and the public or private well is 650 feet. Under that variances, that deals with the setback distances. You can actually apply for and get a variance to be within 400 feet of a private home. And that actually does not require consent from the homeowner. The company can apply for that to the Mining and Energy Commission, and they can approve it without consent from the homeowner. Bonding. MEC rules currently require bonding before drilling commences, rather than before any surface activities commence. And the MEC does have the authority to change that if they so choose. I think my organization, would argue that before any surface disturbance activities, the bond should be required. Drilling units, remember these are the 640-acre, generally roughly 640-acre areas where natural gas could be drained by one well pad. It says that they're going to be roughly 640 acres, which is the national standard. 30-day public notice required before drilling unit applications are to be heard before the Oil and Gas Commission. So the general public should know before we're going to start seeing drilling unit applications, and that would be the initial step in the process. If fracking were going to take place in North Carolina, the first thing that would have to happen is a company, well, beyond leasing, the first thing that would have to happen is a company going to the Mining and Energy Commission and saying, here is our application for this drilling unit. And it will require surface use agreements before the application is approved. So a surface use agreement is generally an additional agreement besides what you have in the lease that says how your surface is going to be used. It doesn't explicitly say that the surface use agreement has to be this in these rules, and the language could be tightened a little bit. Although it does say surface use agreements will be required. But those surface use agreements essentially say you can't put a road through my property, you can't build infrastructure on my property, you can't run over, my grandmother's rose bed, that sort of thing. And those surface use agreements are really important, and anybody who looks into signing a lease should talk to their attorney about also having a surface use agreement. This was while imperfect, it was a good piece of the regulations, because one of the things it may do in some circumstances, depending on how the deeds were developed, it may allow some surface owners on split estates to say, I don't want infrastructure on my property, I don't want a well on my property. And that's something that's a good thing. We want, in the case of a split estate, for that surface owner to still be able to say, I don't want something on the surface of my property. And then trade secrets. There was a provision within the rules that said requests for trade secret protection includes a requirement for an affidavit stating chemicals for which a protection is sought. That means anything that's going to be protected under trade secrets are not regulated under the Federal Safe Drinking Water Standards or National Secondary Drinking Water Standards Act. So this is essentially saying the company has to sign a legal document saying we're not putting anything in the ground that would be regulated under these laws. They don't have to disclose it. They don't have to really provide any evidence that they're not doing it. They just have to sign an affidavit saying they're not doing it. So it is what it is.
Wasn't this activity exempted from the safe drinking water laws?
It was.
So wouldn't anything that they put on the ground not be regulated there, since they already got the exemption?
They would not be violating federal law if they did it. They would just be violating the affidavit that they signed. Ted, is that correct?
Can you repeat the question?
Sure. So this is regarding the required affidavit that says you are not using any chemicals that would be regulated under the Federal Safe Drinking Water Standards or National Secondary Drinking Water Standards. The question is, since fracking fluids are exempted from the Federal Safe Drinking Water Standards Act, what impact does this really have? Is this really protective?
Well, actually, it does provide some protection, because although the fracking fluids are exempted from the Safe Drinking Water Act, what the law pulls in by reference is those substances that are regulated under the Safe Drinking Water Act if they were not in fracking fluid. So they do have to make that certification in their affidavit as to each of those chemicals. So there's some protection there. And I also wanted to jump in because I looked it up, and the person who asked the question is correct. The water test has to be done by a company, a laboratory on DENR's groundwater laboratory that's a participant in DENR's groundwater laboratory certification program.
Okay, great. Thank you, Ted, for clarifying that. Okay, so what's left unresolved? We're down to the last couple of slides here, and then we'll move on to Ted. But what is left unresolved? Forced pooling. As we've been talking about, we don't know what's going to happen with forced pooling, because we still don't know, even though there were recommendations for a 90% threshold, we don't have that in regulations or in statute anywhere. The recommendations have no real power. They are just recommendations. So we don't know how that will play out. And then split estates. These split estates still exist in many North Carolina counties, and in some cases, subsurface owners are unaware that they own the subsurface. So one of the things that could be done is legislation that clears up those dormant mineral estates. So you could extinguish those dormant mineral estates, and there's precedent for this. It's been done in the past and done in other states, and Ted's going to talk pretty extensively about that. And one of your handouts is actually about that very thing, so I will let Ted get into the details. So, how to get involved, the last slide. How many of you have called your legislators within the last year? Awesome. Folks in Western North Carolina call their legislators. This is really great. People in the flatland don't call their legislators much. So I don't have a specific message for you to take to your legislator because it's just an informational meeting, other than to say, I think public engagement is a very good thing. And calling your legislator allows you to have an oversized impact compared to everyone else. If you write letters, sometimes they get there, sometimes it takes a while, especially if you write a letter to Congress, it's going to go through anthrax screening in a, in a building somewhere else before it ever gets there. I mean, really, truthfully. So it may take a while. If you send an email, there may be a staffer that records that email in a spreadsheet, maybe. But if you make a phone call and you talk to somebody and you make a personal connection with them, you will have a bigger impact doing that than any other method of contacting your elected official. So call them. They need to hear from you. Those are your representatives in Swain County, Representative and Senator. Representative Joe Sam Queen and Senator Jim Davis, and those are their phone numbers in Raleigh. Speak at a Mining and Energy Commission meeting. Soon they will be Oil and Gas Commission meetings. There is an email list right there that sends out information about all of the meetings. So that's study group meetings that are part of the Mining and Energy Commission, or full MEC meetings, or committee meetings. If you sign up for that email list, you will be informed about when all of them take place and where. And then lastly, talk about these issues with your friends and neighbors. The average person needs to hear something 5 times before they remember it. I think that's pretty generous because it takes me longer than that. I have to hear it a good many more times than that. But talk about these issues with your neighbors and talk about them often and discuss them often. Have calm discourse with folks. I always think that that's a really good, important thing. And generally nobody needs to be reminded of that, but it's always good to say that calm discourse is the most productive way to talk about this. So talk about it with your neighbors, and then that's my contact information. Thank you all very much, and I will let Ted take it over.
Okay, thank you, James.
Ted, can we just have 1 minute to all stand up and shake our booties? I think they might be getting a little tired of sitting.
The sooner we get through this, the sooner we can go home. Let's roll.
I know, but just 1 second here. Okay, go ahead, Ted.
Okay. First thing I want to start with before I get to my slides is you have among your handouts the State of North Carolina Mineral and Oil and Gas Rights Mandatory Disclosure Statement, which was required by legislation last year. And I want you to focus on 2 boxes, number 1 and number 4, where the seller of property has 3 boxes they can check. They can say yes, the mineral rights were severed, no, they weren't, or no representation. And then number 4, oil and gas rights were severed from the property by a previous owner, yes, no, or no representation. Obviously, if you were the owner of property and the answer was yes, and you knew it, you would check yes. The problem arises, and I'm going to get into this in more detail in my slide, is that if you're not aware that those rights have been severed, it is still fairly unsafe from a legal perspective to check the no box because of the difficulty of knowing with certainty whether or not the rights have been severed. And if you check no, you're warranting that they were severed. So most people who are not aware that rights have been severed, if they're properly advised, they're going to check the no representation box. And we had a discussion of that at the meeting that James and I gave last week. I don't know if you wanted to add anything to that, James, or not.
Sure. So Ted's absolutely right that this form is well-intentioned, but it is likely if you purchase a piece of property that the no representation box is going to be checked, at least in a few cases. My wife and I purchased property last year, and that box said no representation, and we went to our real estate agent and said, we're we were pretty uncomfortable with this. We would really like to know if we own our mineral rights. And the real estate agent essentially said, oh, it's been recommended to all of us that we tell our clients to check no representation. Because if you didn't, you checked, no, the mineral rights have not been severed, and it turns out that they were, you would then be liable as a seller for that property. So while this is well-intentioned, the usefulness of it may not really be there in some cases because so many sellers are going to check no representation, as I found out.
But isn't the real estate agent supposed to know that?
Ted will talk about it. It is very, very difficult to know. Even after an attorney does a title search that goes back 100 or more years, you may not know for sure, for 100%. And Ted will talk about some of those reasons.
We have a realtor right here, in case you want to say anything about that.
No, this is Foreman's new come out. And we still, don't know how to handle because everybody assume you get mineral rights or anything under the house you buy should be yours. But, this form came up and said, how are you going to find out mineral rights?
Yeah.
And then the attorney does go through for legal, the title search, but that won't show up.
Right, right. Yeah. Well, Ted, do you want to take it from there?
Yeah, if you can go to the third slide, please. The second slide is my disclaimer. I am a licensed attorney, licensed in North Carolina. However, I am employed full-time by NC State University and North Carolina Cooperative Extension Service, so I don't give private legal advice. But my contact information is there if you have questions. But let's go to the third slide, which is the nature of mineral rights, which is also true of oil and gas rights, is that they are capable of being severed from the surface. They're further capable of additional slicing and dicing. You can separate the oil and gas rights from the mineral rights. You can also subdivide those rights by depth. So for example, in Ohio and Pennsylvania, where you have the Marcellus Shale, which is fairly shallow, and you have the Utica Shale below it, it is very common when that land is leased that it will specify a particular depth so that only the Marcellus Shale is leased to one gas production company. The Utica Shale may be leased to a different company. And landowners do this to maximize their returns because you're likely to get more money if you're leasing those two different strata of hydrocarbon-bearing shales separately. You can also, if you've got coal bed methane, which goes into the natural gas pipelines, you can also lease or sell that separately. Let's go to the next slide, the importance of the intent of the parties. And when you have an instrument that purports to sell the mineral rights or the oil and gas rights, you will interpret it by the intent of the parties. There's a fairly recent case in Pennsylvania involving a 1883 deed that was issued by the probate judge out of an estate that divided the petroleum oils, that's the term in the deed, between two different groups of legatees. And needless to say, their successors in interest, probably their descendants, once this became valuable with the Marcellus Shale, decided to argue over what the term petroleum oils means. Did it or did it not include the natural gas? And who knows what the intent of a person who was dead in 1883 because it was under the terms of his will actually intended by the term petroleum oils. So some of these old conveyances get very, very hard to interpret. Now, I want to make the distinction between a sale of the subsurface rights and a lease of the subsurface rights. When a landowner sells their subsurface rights, they're gone forever. When you lease the subsurface rights, you will eventually get those rights back when the lease ends. If no commercial quantities of gas are found, that's going to be fairly quickly. The new leases under state law, that's going to be no more than 10 years for oil and gas leases. I'm not sure there's any limit on mineral leases. I'm not aware that there is. Are you, James?
No, the way the statute is written, I believe it just says oil and gas leases.
So, now a lease is very different because if the company that has leased your property goes into bankruptcy, and given the current state of the gas industry right now, that's actually fairly likely, the resource that you have leased does not become part of the bankruptcy estate, because that oil or that mineral in place remains your property until it's severed. So under a lease, that only the lease goes into the bankruptcy estate, not the actual resource. But if you sold it, that resource in the ground is going to be part of the bankruptcy estate of the company that owned the oil and gas rights. So there's an important distinction between a lease and a sale, a transfer by deed. So when you lease property, you have not actually severed the subsurface rights. When we talk about severed estates, we're talking about that at some point in time, those subsurface rights were transferred away. We're going to go to the next slide. Subsurface rights are treated very much like the surface or the property in its unsevered states. They can serve as security for a debt if you can find a lender who's willing to use them as security for a loan, which is unlikely in North Carolina because we don't have a developed industry and it's hard to value those resources, so the banks don't know what they're worth. Now we can go to the next slide. Interestingly enough, under North Carolina law, it appears that natural sand deposits and natural gravel deposits are probably part of the surface estate and not part of the mineral rights. And that's important because if the mineral rights were sold, the sand and gravel wouldn't be part of that sale. Now we're not talking about crushed rock. We're not talking about stone that's crushed in the rock. We're talking about natural gravel deposits. And the only natural gravel deposits we have in North Carolina, of which I'm aware, are along rivers and streams. When you get to northern states that were glaciated, you have very large natural gravel deposits from the glaciers. We do have quite a few natural sand deposits. The other issue is titanium. There's now titanium mining going on in Halifax County, but there are also alluvial titanium deposits in the Catawba Basin and in the Yadkin Basin. And those are probably also part of the surface estate, but we don't have a case on point. So this gets to be important when you have severed estates. Well, let's talk about the relationship between the surface and subsurface estate. That's the next slide. James had mentioned surface use agreements. So if your property has not been previously severed, you can include provisions for the use of the surface in your lease. And that's going to govern what the person you leased, say the gas deposit to, can do with the surface. And that, of course, is very important because if you got cattle, you want to make sure your fences aren't knocked down. You want to make sure that exploration and development people from the gas company don't leave gates open. You want to be very careful about specifying where the access roads are, so it limits how much it interferes with your farming operation. You probably never want to allow them to use the water on your property. You certainly don't want them to store waste on your property or in your property. But if you have never owned a subsurface, you can't protect yourself through the lease. So what you can attempt to do is negotiate what's called a surface use agreement with the gas company, or if it's a mineral, the mining company, as to how they're going to use the surface of your property. And in Texas, for example, the subsurface estate is dominant. North Carolina laws are somewhat uncertain, and the reason North Carolina law is uncertain is we've never had an oil and gas industry in North Carolina. You don't get case law until there's money involved, and people sue each other, and you get decided cases. So without cases, it's very difficult for a lawyer to tell you exactly what the law is. But we do know that the rule of North Carolina is one of reasonable use. And what is reasonable is defined by the method of mining or extraction in the case of gas that is considered acceptable in the industry. And I can best illustrate this by a groundwater case. And this, of course, is very relevant to natural gas because they are going to affect your water, and to the extent that you're not protected by the statute, for example, if you're beyond the 2,500 foot limit, which was originally 5,000 feet, and your water is affected, so it wasn't tested, isn't protected by the presumption, the question is going to be what was reasonable for the gas company. And the same rule applies with water. And the leading case on point is a North Carolina Supreme Court case, Bayer versus Nello L. Tier Company. The case was decided in 1962. It's decided in Craven County. It involved a open pit rock quarry where they were taking out rock to make crushed rock. And the Bayers were neighboring homeowners, and in the process of dewatering the mine, they caused saltwater intrusion, which rendered the Bayers well salty, unusable. And of course, in 1962, there was no county water there, and so essentially rendered their house worthless. So they sued the Nello Tier Company for damages, and what the Supreme Court said is, to the extent that the quarry was operated in the manner that is considered reasonable in the quarry industry, they had no liability for having destroyed the Bayers well and rendering their property worthless. And so I bring up that case because what's reasonable to you is not what a court is going to find reasonable. And that's very important to understand that distinction. So the idea that the use of the surface has to be reasonable is what's reasonable to a mining company or to an oil and gas company. And there's a case from Western North Carolina involving this is an old case, about a 75-year, 80-year-old case involving a company that had the rights to the feldspar under a farm. And apparently it could only be mined by open pit mining, and apparently the feldspar was located under the surface owner's barn. And it's a North Carolina Supreme Court case, and the mining company very carefully took the surface owner's barn apart, and the court found it important that they stack the pieces and put them under a tarp. And apparently the individual that owned the surface was an absentee landowner, and this was all done before he discovered it. Needless to say, when he was discovered it, he was quite unhappy and sued. And the holding in the case was that the minor owed nothing to the surface owner because he had done it in a manner that was reasonable in the industry for feldspar mining. So let's.
So we have one question, Ted. Yes.
Doesn't this kind of give us an idea of what kind of fight we're in?
Yes.
And also I have a question. Is that the EPA is going to get involved?
We have a question about whether or not the EPA is going to get involved.
Only if you touch on an area of federal law. So the EPA, and remember, when you're talking about oil and gas, many oil and gas activities are exempt from federal law. So there's an exemption in the Safe Drinking Water Act. There's a limited exemption in the Clean Water Act. There's a limited exemption in the Clean Air Act. There's a exemption in the law that governs hazardous waste. So when you're talking about oil and gas, your protections, if you have any, are mostly going to be under state law. So, that's where we are. Now, if you actually had waste dumped into a river or stream, then EPA would get involved. However, it works a little differently because of these federal exemptions. And we had a case in Pennsylvania where a waste hauling company contracted with a number of different gas producers to haul away their backflow fluid. That's the fluid that comes out of the well, because you put fracking fluid down, and then you get backflow, which is the fracking fluid plus whatever came out of the well. Now, unfortunately, a lot of what comes out of the well in the wells in Pennsylvania includes salts of radioactive metals. And so there are a number of streams in Pennsylvania that are now polluted with radioactive material that came out of these wells. And this individual certainly wasn't the only one, but part of the reason. He was contracting with these companies to haul away their waste, and instead of properly disposing of it in a deep well injection, which is expensive, he was taking his tractor trailers to the nearest bridge and opening the valve. And he was caught, convicted of federal criminal charges, and sent to federal prison for 6 months. And because these wastes are not regulated under the Resource Conservation Recovery Act or under the Comprehensive Environmental Response, Compensation, and Liability Act, which are the two federal acts that govern hazardous waste, the gas companies had no liability for cleaning up this mess. And in fact, this individual who illegally dumped the waste was required to reimburse the gas companies for the money that they had paid him for waste disposal. Now, had the oil and gas exceptions to RCRA and CERCLA, those are the two hazardous waste statutes, not applied, they would have had to pay for cleanup of these streams. As it was, there was no money to pay for cleanup of these streams because the man who was convicted of illegally dumping had no money, and he was headed to federal prison anyway. So that's the state of the law. You want to add anything to that, James?
No, I think that covers it well, Ted.
Thank you. Okay, let's go to the next slide, extinguishment. And I cover extinguishment in a good bit of detail, both in the brief version is in the NC State Economist article that you have as a handout, and the longer version is the mineral rights and related issues handout. And so the General Assembly, over a period of years, basically from the and I've got a chart in here, basically from 1965 through as late as 2009, passed 10 separate extinguishment statutes. Only 1-42.9, which was enacted in 1983 and amended in 1985, covers the entire state. The other 9 laws cover specific counties, and those are listed in your handout. So 1-42.9 would cover Swain, and I think there may have been another one that covered Swain, but I don't see it. So the idea is that severed estates where the owner of the mineral rights or oil and gas rights has not listed them for taxes, as they're required to do for many years, decades, should be extinguished. But these statutes are a little clumsy. The General Assembly passed the law, but each county was required to advertise at 4 specified times in the paper of record, and some counties did it, some didn't do it. So I can't tell you without doing a good bit of research which counties did and did not extinguish ancient rights, but these statutes also suffer from the fact that they don't extinguish going forward. It was just a one-shot deal. One of the things I talk about in the Economist article is the General Assembly could pass a modern extinguishment law that is constitutional, that would do this on an ongoing basis, but they have not at this time done so. So I've got 2 slides on extinguishments, so we can go on to the next one, James. Let's skip through all the extinguishment slides to abandonment. Are you at abandonment now?
Yes.
Okay. You would think that these subsurface rights, if somebody hasn't listed them for taxes, they haven't paid their taxes. We have owners of subsurface rights who don't even know they own subsurface rights because they've been inherited down through estates for generations. North Carolina had the first gold rush in the United States in 1799, so people have been severing estates ever since 1799. So there's a lot of this stuff out there. And it takes a considerable amount of work to find it because it's the center of interest of natural gas. That was done in Lee County, and they now have that incorporated into their GIS system. And their director believes that they found 97% of the severed estates. One of the difficulties is that some of the old deed descriptions uses the corners large trees. Well, needless to say, in a 150-year-old deed, those large trees they were using to mark the corners aren't there anymore. So it really makes matching the surface and the subsurface up difficult. But abandonment you only have if the owner specifically says, I'm abandoning my rights, and nobody does that. So it's not very useful for cleaning up the property ownership. And the next slide, adverse possession, which is squatters' rights. For similar reasons is not too useful for this. It looks like there's a question, James.
Yes,
Yes, ma'am.
let's say that the old deeds say that you have your mineral rights and but the later on, they were never excluded, but they were never put into the sub, I think, were you on the sub?
Yes, so they were excluded a long time
They
ago.
were not,
Oh,
they were not excluded officially, they just were never put back into or never continued onto the property.
So they, I just want to make sure I understand the question. So
Nobody signed them off, in other words.
nobody ever signed them off?
Right.
Then
Yeah,
you- then you should
I
have-
understand the question.
Yeah, go ahead, Ted.
So, once you've severed the rights, you have two chains of title. You have the chain of title for the subsurface rights, and you have the chain of title for the surface rights.
Which one prevails?
And what was that?
The question was, which one prevails?
The subsurface chain of title is the one that prevails. And this is what makes these title searches so terribly difficult, is if and I've actually seen valid deeds for rights that were severed in the 1850s. Of course.
What do you mean severed? Did they have to officially be given up, denied?
Well, they were officially sold in the 1850s.
Right, but then when they transferred the sale for the subsurface rights, what happened to the old mineral rights and things that were afforded before?
Not sure I understand the question.
So if they were ever
It
severed?
never continued on, in other words.
If-
They weren't
if they-
severed, they just never continued on. It wasn't included
One
in the
deed
deed.
said you were buying the land and the subsurface, and the next deed just said you're buying the land. It didn't
Right.
say you weren't buying the other part, but it was
And
never
that-
sold to anyone else, so it's still there.
And that is precisely the problem. Very often, when the service was sold, the deed for the next owner didn't say anything about the mineral rights being severed. But unless they are recombined, unless you...
I'll do that.
She's talking about property that was never severed.
Yeah, so, yeah, Ted, it sounds like the question is that one deed named both the surface and the subsurface.
The
and
older deeds
Right.
included both, and the newer deeds only included the surface.
Right, and
It
then,
said nothing about severing the old.
right, but apparently there was not an act of severing. There was just a change in the language indicating only the surface and not the subsurface.
Well, no, if the subsurface rights have never been severed, your deed doesn't have to say anything at all for you to have the subsurface rights. Because the presumption is that the surface owner also owns the subsurface.
Right.
Okay, all right, we cleared that up, that's good.
That you don't necessarily know that you don't own them because your deed doesn't say anything about it. Does that make sense?
Yes.
Okay, continue on, let's go to the next slide. So to have squatters' rights,
See, we brought our
the resource actually has to be mined, or in the case of oil and gas, drilled and exploited, and so unless you have that happening, you don't have squatters' rights in the subsurface. Let's go on to the next slide on conveyancing. The rule in conveyancing is caveat emptor, which means let the buyer beware. And that means that it's up to the buyer to determine what rights they have. And the problem is that a standard title search goes back only 30 years. If you do a mineral rights title search, you've got to go back 200 years. And so that search is much more expensive, and even that can't provide a 100% guarantee that you own the subsurface. And we've seen this problem in Pennsylvania. One very well-known case, it was even in the Wall Street Journal, where an individual actually had spent $5,000 or $6,000 on a mineral rights title search, before he leased his land, he made the mistake of guaranteeing the title to the gas company, which if I were leasing my land for oil and gas or leasing it for mineral production, I would never guarantee the title. I would leave that up to the mining company or the oil and gas company because they're in a much better position to handle it if they don't have the title. So the gas company in Pennsylvania actually required the landowner who leased the land to them to refund the money they paid him because somebody with a superior title came along and sued the gas company demanding that they pay for the gas that they had acquired. And it's really put this landowner in a very bad position because you can only file a amended income tax return for 3 years. So anything before that he couldn't file, and so he's paid tax on the money, and now he's been required to refund the money to the gas company. So that's one of the reasons that in all of the programs that James and I have done, we've said don't sign a lease where you're guaranteeing the title. And we can skip over the next slide on conveyancing to condemnation. And subsurface rights can be condemned in the same manner as surface rights. Where you have some of these ancient interests, the only way to put them together again is by, unless you can get agreement, but if you've got 50 owners or 100 owners and some of those are children under the age of 18, the only way to do it is with a partition action, which is quite expensive. Let's go to the next slide on taxation. Taxation is the same and valuation is the same as for the surface. The problem for a lot of these rights, for gas rights, we don't know what they're worth because there's no gas industry in North Carolina, which is one of the reasons that the big holders of these rights haven't been paying taxes on them because they know the counties won't come after them because they can't get anything if they do a tax foreclosure. So the counties where people have listed them for taxes have just been valuing them at $5 an acre. So this is a serious issue. And by the way, there used to be a lot of large timber company holdings in North Carolina. When they sold off that land, they only sold the surface. They kept the oil and gas rights and they kept the mineral rights, and that's right there in their deeds. And I have run into some very serious problems where the person that had bought the surface has been unable to get financing to build anything on the property and has been unable to sell it because as soon as the seller sees the chain of title and that they don't have the subsurface, they can't get a mortgage to buy the property.
Can I say something?
We've got two questions. We'll start with you and go to you. Yes.
Who gives them the right to take anything from the subsurface? Say there's a large subdivision, and the subsurface has not been sold with the subdivision. Who can go in underneath that subdivision to get those rights? Where does that?
That's the so that would be the forced pooling mechanism through which a company could say, yeah, a company could say, you know, we don't know how this would work again because the statute is unclear, but in theory, the company would be able to file an application to force pool in landowners who have not leased, and if that application were approved by the Oil and Gas Commission, then they could include those landowners in the drilling unit whether they have leased or not. Yes, ma'am.
Well, one thing, if you find out you don't have a mineral rights, check tax record. Those who have the title for mineral rights, make sure they pay. If they don't pay 5 years, you can take to the court and then kind of abandonment and then take the mineral rights from them.
So there was a comment about not paying taxes on mineral rights for 5 years being abandonment, being able to take those mineral rights owners to court.
That is not the case. that is not considered abandonment, and the only way that those rights would be extinguished is for the county to bring a tax foreclosure action. And that's one of the reasons that we, in my opinion, very seriously need legislation to clean this up. Going on to the existing restrictions, next slide. So in general, whatever land use restrictions you have on the surface, zoning, and you covered some of this, James, existing security interest in the property, conservation easements, USDA and sometimes state conservation programs, those all apply with the exception that by legislation, the General Assembly has sharply limited local land use control over natural gas development activities. I would also add that if you have land in the present use value taxation program and you lease your land for gas production, to the extent that the land's converted to gas production, you're going to owe the 3 years of rollback taxes. So if you're signing a lease, you had better make sure that you have a provision in the lease requiring the gas company to reimburse you. Let's go on to the next one, rights granted. I've already really talked about that. If you're signing a lease, you really don't want to allow your water to be used. You don't want to allow them to store waste. You need a restoration provision. And as oil and gas prices have dropped, this has become a major issue in gas and oil producing areas because there has not been enough money set aside through bonding or other means to pay the cost of plugging wells. And there's been some recent articles about the problems that states are facing with this. And of course, as you know, it ends up being the taxpayers of the state that pay for doing this once the companies are long gone. So let's go to the next slide, surface rights owners. I've already talked about surface use agreements, but I re-emphasize their importance. And I talked about the, let's go to the next slide, tying the surface and subsurface together. And I've already talked about this as well, just how difficult it is to figure out where on the surface that mineral rights deed is, unless it's a recent conveyance. And the last slide's on compulsory pooling, and I think that you covered that pretty well, James. But I think we're a little over time, but I'm happy to take some questions if there's time to do it. So I'll turn it back to you, James.
Thanks, sure. James. Thanks, Ted. You did a great job. We appreciate it.
Sure. I'm happy to stick around for a little while and take questions. If anybody wants to hang around or take questions now.
And you have a card in the back here
I
somewhere?
do. I have a card in the back that's on the table back there. If anybody would like to take that.
And there's a sheet that you can put your name on if you want more information from James and his organization. I just want to say that we've got at least 4 grassroots organizations that are represented tonight. Joan is with Mountain True. Sally is with Clean Water for North Carolina.
Roger with water.
He's director of watershed for the Tuckasegee River. Roger, yes. And we've got Avram and we've got Garrett here. They're both Canary Coalition. So if you wanted to talk to any of them and get information on what they're doing, you're welcome to talk with them after we're through. Thank y'all for coming.
Thank you.
Water.
Yeah,